All right, you got more questions?
No, I'm just trying to figure out what it's.
Okay, great. Yeah, no problem. Well, this is excellent. Okay, so hello everybody. My name is Brad Barth. I'm a partner of the firm of Barth Calderon. We're a firm located in the LA area in Orange County, California, and we specialize in the areas of advanced to basic estate planning practice, which is how to properly position your assets for transition to the next generation. There's actually a proper way of doing that. We also do asset protection planning, which I think was a question that came up, and some of you may have heard some partners from my firm before. We had Mr. Michael Bader was probably here before, as well as my father, Harry Barth, was here before, giving talks on asset protection planning, which is a very important topic when it comes to ownership of rental properties. This talk, however, is going to be geared more towards estate planning basics. It's kind of an overall 360-degree conversation. When you have assets and you're talking about legacy planning, we're always kind of concerned about wealth accumulation and wealth preservation during those accumulation years. In other words, basically accumulating those assets with the intent of basically have them for yourself as far as income, as well as being able to transition those assets for the benefit of your beneficiaries, whether it be a surviving spouse or adult kids in the future, and also how to protect and preserve that inheritance, that legacy, for the benefit of the beneficiaries. Again, for the benefit of a surviving spouse or for the benefit of your adult kids. And so this is what I would say the back end talk of an overall asset protection conversation. It stands on its own. It's an important conversation. The gentleman up front here gave me some very good questions having to deal with tax issues. And I think it's called step up and basis, which is very, very relevant in the real estate market. And one of the very few remaining, I'm off the camera here, one of the very few remaining tax havens we have in our Internal Revenue Code. So just by way of brief introduction, my name is Brad Barth. As I mentioned, I'm a partner of the firm. I've been doing this type of work for 21 years. I kind of got my start in the area of estate planning with my father, Harry. My father's been in California as a practicing attorney since 1992, and I've been with him since 1997. So in the areas of estate planning, not only do I do the planning itself, that's sitting down with clients and drafting their wills and trusts and powers of attorney, I also do trust and estates administration. That's basically when someone becomes incapacitated or when someone passes away, someone has to look at your document, interpret that, and help the surviving spouse or the beneficiaries implement that plan. It's called estate or trust administration. I also do trust and estates litigation. This is where the kids are fighting over the piano, right? Or they have Uncle Bob is the trustee, who's a great trustee now, but he's a bankrupt drunk 20 years from now when you pass away. How do we remove and replace Uncle Bob? So that's why I do trust and estates litigation in that respect also. And finally in this area, I'm also a professional trustee. So for those of us who have maybe kids that are too young, or you don't want to use the Uncle Bob because you may love Uncle Bob, but you wouldn't want to give him your checkbook, So who do you trust to be able to administer your assets for the benefit of your spouse and or for the benefit of your surviving kids? So I kind of filled that role as well. So the important thing is that I think in the next 90 minutes, if you ever had a question about estate planning, not only in your own personal circumstances, but also don't forget, estate planning is multi-generational. A lot of what I'm going to be speaking about is going to be directly relevant to you in your situation. But also remember, we all may be beneficiaries of mom and dad's estate. So how do we deal with mom and dad's estate? Or we may have adult kids. How do we deal with the kids' issues? How about the kids' inheritances? What about the kids' drug and alcohol problems? What about the kids that have potential divorces on the future? How do we protect and preserve the inheritance from them or from overbearing spouses or special needs issues? These are all the things that kind of come up. And also what's with the Tax Act, not only from what President Obama did for us back in 2013, but more recently what President Trump did for us at the beginning of 1/1/2018, and how does it affect you and your plan? So that's kind of what this is all about. And on the back end, we still have a responsibility to also talk about charitable planning. Having drafted thousands and thousands of plans over the last 2 decades, I always make it a point to educate my clients about charitable planning. Because I can tell you that, but for me asking them about charitable planning, it's always like the last thing on their mind. Oh, I want all for my spouse, and then all for my kids, and then if not for my kids, my grandkids. If not, then my brothers and sisters, nieces and nephews. And if we're all gone in an earthquake, okay, maybe we'll get to the church. But there should be a responsibility. I find that most people are charitably inclined, but they just don't know how to give. So I'm going to conclude probably in the last 15, 20 minutes what I call the seven basic tools and techniques that we use for charitable planning. I would feel I didn't do a complete picture for you if I didn't give you at least some information about charitable planning. Yes, sir.
Hey, Brad, sorry to interrupt. I just wanted to make sure that the online webinar was running. We just have some people saying they're thinking that's it.
Oh, okay. Let's go with. I'm looking at participants. I only see Paul Hitchcock.
Okay, I'll reach out to Paul.
Yeah.
And I'll get the URL. So, because they're not able to access it.
Yeah, because this is I'm on his account.
Okay.
Because he's the one that set everything up. Okay, cool. No problem. Yeah. As I like to tell my kids, I just pay the bills, you know? I just pay the bills around here. Okay. So from an agenda and housekeeping for today's talk, we're going to speak about the need for estate planning, benefits and scope, and what is probate. And I also do an entire different talk about buying and selling property within the probate environment. It's beyond the scope of today's conversation, but I do these type of talks to realtor associations because there's also a wonderful opportunity for those of you who are involved in purchasing rental real estate, not only on trustee sales, but also on probate sales. Right? It could be a great place to do it. So I have give you all about what's with probate, how you can use that to buy property. And then, of course, we'll be giving you planning tips throughout the course of the conversation. And then here, of course, whenever you're talking about estate planning, you got to deal with taxes. So we'll talk about what's with the 1118. Remember, talking about what are the two certainties in life, everybody?
Death
and taxes. And what's today's conversation all about? Death and taxes. Okay, so it's relevant stuff. Okay, so and then I'll tell you about some recent developments. And then here, I mentioned already charitable legacy planning. I'm not going to talk about the business. I just didn't update this particular slide in preparation for this morning's talk. But that's kind of what's on the hip parade. And in the materials that's on your desk here, if I could ask you to take out two pieces of information. One here is the PowerPoint presentation. Okay, PowerPoint. Go ahead and take your notes on that. And also take out the yellow sheet here. This is our attendee sheet. And keep this attendee sheet handy because as I march through this material in the next 90 minutes, there's going to be something that may be very relevant to you that you want to address in more detail, whether it's something for your particular circumstances, maybe mom and dad's circumstance, maybe for your kids, maybe a blended family situation. Give me a couple of notes. I call this the Ask Brad section. Give me a couple of bullet points, and then I'll collect this at the end. And then we always offer, whenever we give presentations, we always offer a 1-hour complimentary consultation to address any questions because we're not really in an attorney-client communication environment right here. So if you want to give me a call, it won't cost you anything. It's an hour free time to drill down on any specific questions that you may have. But to make maximum use of your time and my time, give me a few bullets. Some people also write on the back, and we go ahead and get those questions answered for you. The remainder of the material is just some printed out stuff as far as what some of the written material I'll be speaking about. And there's an article that I wrote back here about the 10 estate planning mistakes, and you can read this stuff when you have a bout with insomnia at some point in the future. All right? Okay, let's kind of get right into it. Good morning. My clicker's not working. There we go. Okay, so whenever we're talking about estate planning, we have to start out with the definition. Okay, what is an estate? Always need to be very careful because definitions are important in our area of practice. So when you think about an estate, most people, especially you guys that are involved in rentals and dealing with banks and financing and refinancing properties, you're pretty familiar with your overall net worth because you have to provide financial statements to the client, to banks. And so when I ask you what your overall net worth is, many people say, okay, I'm worth a couple $1 million. And now when we're talking about estate taxes, the numbers are currently astronomical numbers. Back in the days of Bill Clinton and George Bush, we started to have an exemption amount of about $1 million. You could transfer $1 million of assets between you and your kids before you incurred an estate tax problem. Then during the George Bush years, those numbers slightly increased up through the Obama years. Then it became $5 million. You guys may be familiar with this. You had $5 million, and if you are married, you can double up that exemption. So you had $10 million. That's like a huge amount of money. It was already, at the end of Obama's presidency, the highest estate tax exemption that the world has ever seen. And so we're talking about people's net worth because it talks about transitioning assets from a decedent to a beneficiary. We're talking about the net worth. And when you start getting into the Obama numbers of $10 million for a married couple or $5 million for an individual, you start saying, wow, man, I'm way under that. I'm only worth $2 or $3 million. But what they forget about is life insurance, right? Because on our financial statement, we list our real estate, our business interests, our personal property, our retirement assets, maybe the cash value of life insurance policies. But what you don't typically list is the death benefit of a life insurance policy. But for purposes of estate tax calculations, the death benefit is tax inclusive. So why is this important? So you have a net worth of $3 million, very realistic in California to have those type of assets. You say, okay, I'm under $5.5 million, no problem, that's totally cool. Oh, but you forgot you have a $3 or $4 million life insurance policy for the benefit of your spouse or your kids. So when you die, what's your net worth? Let's say you've got $3 million of your own assets and you got $4 million death benefit. What's your overall estate for estate tax purposes? 7. 7 is more than 5, which leaves about a $2 million tax on $2 million taxable estate, subject to a 40% tax, right? So about $1 million in tax. Why? Because you didn't consider the estate taxes. Why is this still relevant? Because President Trump, as of 1/1/18, now made that exemption $10 million per person, $11 million per person. And if you're married, you double it up. That's $22 million. Okay, that's like stratosphere. That covers almost all but the most wealthy Americans as far as the amount of assets that they transfer. But that is set to sunset in year 2025, where it goes back down to the Obama $5.5 million. So the numbers that we're talking about are still relevant. Estate taxes are still an issue. Okay, so I want you to be aware of that. And so when we're looking at what makes up an estate, you've got to consider death benefit of life insurance policy. Don't just look at your overall net worth statements. It's very important to understand what is the estate that we're dealing with. Happens to be a rude surprise for a lot of my clients. And so what is estate planning? As I mentioned already in my opening comments, it's also not only about who gets your stuff when you pass away from a legacy perspective, it's also asset management during your lifetime. If you're going to talk about estate planning, you're talking about creating a legacy you want to pass for the benefit of your spouse and your kids and your grandchildren. You want to leave a legacy with the community. Well, guess what, guys? You got to have stuff. You got to have assets. So it's no point in drafting up a wonderful estate plan that goes on for multiple generations. You ain't got 2 nickels from it, right? So having asset management during your accumulation years is very, very important. And then you probably heard my father speak, and I think you may have heard Michael Bader from my office speak. We start talking about asset protection. How do you protect those assets from the claims of third-party creditors? And unfortunately, in your line of work, your chosen profession, as far as being landlords, there is an inherent liability with landlord-tenant relationships. And I tell my clients all the time, if you take $1 million and you put it in the bank in a CD, or you buy a mutual fund, what's the likelihood of that bank account suing you? None, right? But you take the same $1 million and you buy a piece of property and you put a tenant in there. What's the likelihood of that tenant suing you?
A lot higher.
A lot higher, right? So you have to address that. So part of what we're concerned about is asset protection. And some of the biggest issues I deal with as an asset protection professional is how to deal with clients when they have landlord-tenant issues. They have very, very high standards of duties, and landlords are a little bit of a target. So how do we protect our assets from creditors, predators, liens, and judgment holders? So here again, if we're drafting an estate plan to take care of our spouse, our kids and grandkids and the community, and you're one lawsuit away of losing everything, again, it's going to be basically a defunct plan, right? So you got to make sure that asset protection as well as asset accumulation is part of your estate plan, believe it or not. Planning for disability and incapacity, surviving spouses' needs, succession planning, charitable planning, again, we'll talk about that. And then here, how do we maximize the wealth transfers to the family? So even if we were to put your assets together in such a way that it's able to withstand predator attack during your lifetime, What happens when your kids inherit? What about your kids' creditors? What about your kids' spouses, right? Future divorces. We have to be worried about that stuff also. So another big concern for a lot of my clients is, how do I protect my inheritance I'm giving my kids from the claim of my no good son-in-law? Right. Believe me, it happens. No good Nick over there, right? Son-in-law. So we have to worry about that as well. So this is a big part of what we speak about as well. Okay. So just a couple of rhetorical questions. The likelihood that we're going to get older is, it's 100%, right? It just happened a moment ago, right? We just got a little bit older. So along the same line of thought, what's the likelihood that we're going to pass away? It's also 100%, right? And I put these slides in the beginning of my estate planning talks because for some reason, people just don't want to do estate planning. There's some statistic like 30% of Americans have done estate planning, which means 70%, the substantial majority of people haven't done it. I mean, you got some secret that I don't know about? And the funny thing is, in states like California, we are a statutory state. So believe it or not, whether or not you took the affirmative steps of putting together an estate plan, you actually have one. It may not be your plan, it's actually Jerry Brown's plan. It's the state of California's plan. We have what are called laws of intestate succession, which means if you pass away owning stuff, there is a natural order of who's going to get your stuff, whether it be your spouses, and it makes a difference whether you have community property, whether you have separate property, whether you're married, whether you have kids, whether you have a blended family. It all gets very, very complicated. And so if you don't have a plan that takes these issues into consideration, the state's plan will do it for you, which for most people is not a good idea. And this is kind of what it looks like, the will of Paul Procrastinator. I direct that all of my assets be converted to cash, all of my debts paid, including taxes, probate fees, admin fees, and attorney's fees. This is where you see things like probate sale signs or estate sale signs out in people's front lawn. They're trying to liquidate their stuff. Or fire sales. Kids who live in New York don't want mom's property here in Oakland. So they're just going to sell it and get rid of it. The property's going to go to waste. When each of my minor children obtains the age of 18, I direct that his share be paid to him outright, regardless of his financial or emotional maturity. Right? This happens all the time. So you pass away, you got a kid who's 14, 15 years old. They will not be able to inherit, nor can a life insurance policy pay out to a 14-year-old kid. You create what's called a conservatorship or a guardianship of the estate. But when the kid turns 18, then they get all the money. So let me ask you something, right? You're 18 years old, mom and dad drop dead, you inherit $1 million. What happens to your life?
Your money's gone.
Yeah, right? It's like crazy time, right? So not only does it put your kids off the path, statistically speaking and personal experience speaking, they're either dead or broke a year later, maybe 18 months here later, right? Because they don't have the financial maturity and how to deal with that. So they didn't have to earn it. It was given to them. And as a result, it's completely wasted. So it's very important. They don't have the financial maturity to deal with those kind of monies. And here, if I am not survived by my spouse, my kids, or my parents, I direct the probate court to seek out my closest blood relative and divide my estate among them in a way which gives each an equal share to my closest relative or to their descendants. This reminds me of the movie Brewster's Millions. Remember that movie with Richard Pryor? Well, all of a sudden you have some uncle thrice removed you never met before, and all of a sudden, hey, guess what? You just inherited $100 million. And what do we call the Richard Pryors of the world? Laughing heirs, right? Because they laugh all the way to them. Right? That can happen as well, unless you put some steps in there. And lastly, if no relatives are located, and how do we do that? When someone passes away, we have to file an affidavit with the court that we made certain due diligence attempts to try to locate all of your heirs. Public record searches, private investigators, et cetera, et cetera. And if we're unable to locate them and we have no beneficiaries, you then direct that all of your property goes to the state of California. It's called, it escheats to the state. Not escheat, but it escheats to the state. Right? So if you haven't paid California enough during your lifetime, your entire earnings will not go into the general fund unless you make some affirmative steps. So whether you have a plan or not, this is what it is. Right? This is a typical intestate succession. So we want to make sure that we direct You hear this all the time about probate. So what is probate? And it has a bad connotation, and I think we're deservingly so. So probate is a state's way of distributing your assets because you didn't put some instrument in place to do it for them. In other words, you pass away owning something, right? You got an asset in the name of a dead guy. So now you have the beneficiaries who want to take dead guy's stuff. Dead guy's stuff could be a house, bank accounts, insurance policies, whatever. You just can't walk into dead guy's house, the kids, and say, mine, right? What happens if the kid tries to sell a property that's in the name of dead guy? Will he be able to sell it?
No.
No. Will he be able to get access to the bank account? No. Will he be able to get title insurance for good marketable title? No. Why? Because title's in the name of dead guy. But if the owner has passed away, one of the rights that we reserve as property owners is the ability to transfer assets. It's one of the bundle of rights we have in property ownership, the right to transfer. Well, if the person who reserved the right to transfer is dead, who steps in the shoes to transfer good marketable title from dead guy to beneficiary? That person is the probate court, probate judge. That's what probate is. Probate is the legal process by which assets of a decedent are then transitioned over to a beneficiary through the court process to transfer good marketable title. Then you can sell the house. Then you can get access to the bank accounts, right? But it comes at a cost. Probate here in California is under the California Probate Code section 10800. And if you look at these numbers, there's two things you need to pay attention to. First, look at the numbers. And secondly, look how the numbers are calculated. I opened up my comments about estate taxes and I said your estate tax is based upon your net worth, right? Minus debt. In probate land, we calculate our fees based upon gross value.
Scary. Why no flat fee?
Because we wrote the rules, man. See, I don't have a 401k plan. I got a 10-800 plan. See, $1 million in California gross, which every one of us who owns a piece of property in California practically has $1 million gross, is going to result in attorney's fees of $23,000. I don't even have to ask you for it. It's in the probate code. And then the executor that you listed, your attorney or your friend or your sister, they get the same fee that the lawyers get. So you pay your attorney $23,000. You pay your CPA or sister executor $23,000. That's 46 grand, and we haven't even filed the papers yet. We haven't notified your creditors yet. We haven't paid your estate taxes yet, right? It's extremely expensive. Yeah. Yeah. It's very, it's based upon gross. So like I said, you got $1 million gross value, but it's completely mortgaged out. You got a mortgage of $950,000 on $1 million property. What's the equity? 50 grand. But what are we billing you off of? $1 million. I'll slap an attorney's lien on the property until I get paid, right? That's what happens. And the funny thing is, you may say, 23,000, that's outrageous. Of course. So you're going to say, you know what, Brad, screw you. I'm going to go to the lawyer down the street. And what's he going to tell you? $23,000, right? Because it's by law. That's right. So basically, that's one of the reasons why you want to avoid probate. It's expensive and it's timely. I would never tell my clients anything less than 18 months. 18 months. My aunt passed away she's in the Bronx in New York. She passed away in January of 2017. I'm her executor, right? It's now going into what? Almost 18 months. We're 17 months. And I still haven't been able to close her estate. And it was very, very simple in New York. And I know what I'm doing. I do this for a living. And it's still complicated. So it's a very expensive proposition, and the assets get tied up in a stay while you're in the probate process, right? one of the most complicated ones I have right now. I'm on 3.5 years. I'm still dealing with this. So in here, and also it's completely a lack of privacy. It's completely public, right? Like any other court proceeding in America, it's completely open to the public. So if you want to see who are going to be the beneficiaries of Prince's estate or Michael Jackson's estate or anybody else, just go in the probate court and look them up. You'll see who the beneficiaries are. You'll see what the assets that they're going to be inheriting. I mean, recently, the last 5-7 years or so, we just started redacting beneficiary social security numbers. And what happens here is you have people who go to the probate court. I see them there all the time looking up a dead guy's name, and they see little Johnny, this is inheriting $1 million. And what happens? They start getting postcards in the mail, sell the property, come to my seminar, right? Because they want to kind of capitalize on that newfound wealth of little Johnny who doesn't know how to deal with the assets. And how do I know this as a fact? Because I'm the executor for a lot of my clients. And who do you think receives all these postcards from these guys? I do. And it goes right in the garbage can, right? So I'm able to basically be a firewall for the benefit of my beneficiaries by having that in there. So it's completely public. And if this isn't bad enough here in California, and this is important to you guys also, if you have property in other states, so if you want to buy property like in Michigan or Arizona or Texas, but you die as a California resident, not only do we have a probate here in California for all of your California assets, you have to have what's called an ancillary probate in every other state that you own real property. So if you have a property in Florida, you have a property in Michigan, you're going to have another probate in those states. And the reason being is very simple. California courts can't tell Nevada what to do with its dirt. It's a separate sovereign state, right? We fought a war over that stuff, right? So you have to have another probate with its cost and its time consumption. Again, so if you own real estate in other states, and very important reason to have these assets in trust, you don't want to have to go through probate. And if you have a will, people understand, oh, I have a will, I'm not going to worry about probate, Brad, I did an estate plan. That's also incorrect. And this is a big misconception. If you have a will, who do you think the only person who's authorized to read and implement your will is? The only person who can read and implement your will is the probate court. A will is a guaranteed admission ticket to probate. But so wait a second. But in my will, I created a testamentary trust. I created a trust and I designated the trustees. If you did that through the will, why not create it during your lifetime called a living trust and fund it during your lifetime? Don't go through probate just to create the trust that you should have created during your lifetime anyway. Okay, so wills themselves are not asset protection tools. Another big thing for you guys is up here as well. What about joint tenancy type of assets and other forms of title? Joint tenancy has what's called a right of survivorship. So if any of you've taken property with a business partner and you've taken it as joint tenants, you know, Mary and Jane, you know, best friends, as joint tenants, 50-50. Well, you have inherently what's called a right of survivorship, which means both of you own the property 100%. You don't own it 50-50. You own it 100% each. You divide the income 50-50 and the expenses 50-50. But what happens when one of the partners dies? You file an affidavit of death of joint tenant, right? And then the surviving joint owner walks away owning the property 100%. Why? They always owned it 100%. What happened to the family of the deceased joint owner? What do they have? They got nothing, right? This is an unintentional disinheritance. So if you've taken property with siblings, with friends, with parents as joint tenancy, be aware it has an inherent right of survivorship, which causes an unintentional disinheritance. Not to mention unintended liability exposure. There's a crossover here with asset protection. Because if you have a property held jointly with your business partner, and your business partner gets sued because they ran the red light for somebody, what did I just say? Each of you own the property 100%. meaning it's subject to your business partner's creditors just as much as up to yours. So they can have a liquidation of your own and a petition of your own property. So you can lose it that way too. So it's inherent asset protection problems. Unintended gift tax consequences, this happens all the time, not only in the areas of real estate, but also bank accounts, right? Someone says, and it's very, very common. I have a lady, an old lady, she wants to go ahead and put the good son on as, the estate plan says all my kids equally, a third, a third, a third. Everything's a third, a third, a third. But the good son who's helping mom with the bills and helping her with the accounting, she puts the good son on $250,000 as a joint owner on the account for convenience. So he can get access to the account, help pay for the medical care, and et cetera, right? Well, the first problem you had there is that when she put the good son on as a joint donor, she just had a $235,000 gift with a gift tax problem. And the second thing is when mom then dies, what did the estate plan say? It said a third, a third, a third, right? And so the house that was part of mom's assets went a third, a third, a third. But the good son, who was on as a joint tenant on the 250 bank account, what did he get? All the account. So he walks away with a third of the property and $250 in cash. And the two siblings are saying, hey, man, mom said a third, a third, a third. Where's our part of that 250? And what does the good son say? If mom wanted you to have the 250, she would have said so. She would have put it in the trust. She didn't, therefore it's mine, and I owe you nothing. This happens all the time. All right, this is I see this all the time, right? So be aware of these things. This happens all the time. So the proper way to hold property should be in an LLC or as tenant in common. If you don't want the asset protection nor the ongoing expenses of an LLC, which is the proper way to do it, then at least have the property held in a tenant in common. At least this way, your portion is now divisible. You can inherit your ownership in that land. It's no survivorship interest, it's tenant in common. But the proper way actually is to have it in an LLC. Not only do you want to be protected from the claims of your tenants, you also want your property to be protected from your own personal liabilities as well. You don't want your creditors taking your property, and you don't want any liability coming from your tenants, okay? LLCs provide that for you. That's the proper way to hold property. Another area we deal with a lot is in areas of contracts, IRAs. Yes, ma'am.
If we bought our property in a loan under our own name, and the loan says if the property changes hands, you have to repay the loan.
Right.
Making it into an LLC means you have to change your finance.
Right, so what she's referring to is the due on sale clause of a loan. Now the important thing to note about this is that using your example, ma'am, we'll just say that's you and your partner, all right? Or let's say husband and wife, or you and your kids, or whoever, are on the property together. Typically it's husband and wife, so I'll use that for this example, husband and wife, 50-50. You own the property 50-50, and the bank underwrote the loan based upon the credit worthiness of the two of you as owners. You then form an LLC that's owned, same partners, 50-50. Now, when you take that property and you put it inside the LLC, it was owned 50-50 before, it's owned 50-50 after. So in reality, in this example, you don't really have a true change of ownership. What you have is a change of how you're holding title. Not holding title as an individual, you're holding it now as an LLC. Very different. And so I can tell you on one hand, over 20 years, how many times you had to deal with banks with due on sale clauses and situations like that is less than this. And even then, they charge them $100 to add the LLC on as an additional obligor on the note. It's when you change ownership. If it's you and your husband or you and your partner, and then you start giving the property to some third party. You put it in an LLC, it's not owned 50-50, it's owned a third, a third, a third. Now the bank's saying, wait a second, who are you giving my collateral to? Now you're changing the bank's position. You see that? That's different.
So for the webinar, you need to click the something in the middle.
Okay.
Broadcast.
Okay, where does it go? Yeah, you want to fiddle with this?
Broadcast.
Yeah. Well, that's
It
all that I
doesn't
said.
say
Yeah.
broadcast.
Yeah. We'll figure that out. So this is the issues that we do. So I wouldn't worry too much about that due on sale clause as long as you have apples and apples on both sides of the transactions. If you have apples and oranges, different situation, right? And even in more complicated transactions, there's ways that we can still get around this, all right?
So if it's the same owner who wanted to do it LLC, the bank should have no
No,
problem.
the bank should have no problem. The bank is more concerned when you start giving it to somebody else. There's two things. First, remember, you're still on the hook personally. And secondly, their collateral is still secured. It's still a secured collateralized note, right? It's when you change the bank's position. That's when they get nervous. That's when they exercise due on sale clauses. And rightfully so. Okay.
Or just to add on to that, let's say, I'm the owner and I go from me to LLC, it's just me.
Right.
Now, and the bank knows this, we're all good. Now, a year later, I decide I'm going to add my wife and daughter to this property.
Right.
The bank probably won't find out
Right.
necessarily that
Right.
this LLC has been changed.
Right. So here's the deal with this one. Okay. And this is one of these like, okay, there's things, it's called stepping on landmines, right? This is a landmine. It's a huge one. Here's your problem. So everyone, when Prop 13 came around, people were getting clever, just like you were just saying. Okay, they're not going to know about what. I don't want my property getting reassessed. I want it transferred to somebody else. So they would put the property inside an entity, specifically an LLC or limited partnership. And then they would start shaving off membership interests of the LLC. When you do that, you're legally required, and if not you, certainly your CPA, to file a form called a BOE 100B form, Board of Equalization 100B form, to show, because you're right, they have no way of knowing. Nothing's getting recorded. So you're obligated, right? A true story, man, right? You're obligated to file this BOE form. And when you trip up a change of 50% or more of that underlying entity, boom, reassessment. Now, it's 50% of ownership. It's 51% or more. It's more than 50% of ownership or management and control. So that's a problem. But in your scenario, it's a little bit different because adding spouses will never cause a reassessment. And typically when you give to your kids, there's a parent-child exclusion on giving to your kids. No problem there. So you're excluding reassessment, but the problem you may be having is with the triggering of the loan because you added your daughter. Maybe not so much your wife, but your daughter. When you add your daughter on, you changed the ownership structure. So don't confuse the due on sale clause with Prop 13 reassessment. So it's different. There's issues there.
Thank you.
Yeah, no problem.
But do you want to take a little pause the foods here and then we want to get
I'm fine. We're good. We're good on time. But go ahead.
But I had somebody advise me against adding children to the property because then they lose a one-up status on taxes.
So we're going to answer this gentleman's question all at the same time. Okay. So what she's talking about is what's called basis and step up and basis. This is huge. And California, as crazy as we are, we're only one of 13 states in the country that's called the community property state. And we get a little special bonus for being made so crazy in the country, okay? I say we're called the People's Republic of California, okay? We're just a little crazy here. So what's the benefit of living here? One of them is when one spouse dies. It's awesome, right? You get what's called a step up and basis. What does this mean? Very simple math. You buy a piece of property for $100,000, right? 20 years ago. At date of death, it's worth 1.1 million, right? So our original basis is 100,000. At date of death, it's 1.1 million. So how much gain do we have in my example here?
900,000.
No, we have a 100,000 and it's worth 1.1 million. We have $1 million in gain. You sell that during your lifetime, you're going to have to pay a capital gain tax at a federal level, and you got to pay a state of California capital gain tax. Plus, there may be a little extra Obamacare tax just for good measure, right? Probably about a good 32% capital gain tax on that sale. So you have $1 million of gain. That's $320,000 in capital gain tax that you got to that you gotta pay. So you net $680,000 in that transaction. And if you gifted your kids the property, the donee takes the donor's basis. That's the legal way of saying that the donee, the recipient, takes the donor's basis. So mom and dad had the property at $100,000, the donor. The donee, the kids, take mom and dad's basis. So what's mom and dad's basis? $100,000. They go and sell it. It's $320,000 capital gain tax, whatever it is. Ouch. Problem. But now you die. If you die owning the property, what's my value? Date of death, I said, is how much? No, it's 1.1 million. Now the base, you get the property appraised, a legit appraisal. IRS requires a legit appraisal, no drive-by stuff, a legit appraisal. And now the basis is 1.1 million. You sell it date of death plus 1 day for 1.1 million. Your basis is 1.1 million. Your sales price is 1.1 million. 1.1 minus 1.1 is how much? Zero. At 32%, zero. So kids say, I want mom to give me the property now. I say, listen, with all due respect to your parents, let them die owning it. You're much better to inherit it.
Yeah.
You get that? Did you get that?
Thank you, yes.
Right on. Yeah.
So in an LLC, it's not a good idea to add your son or daughter as a member of the LLC.
That's not true. Not true. Not true. You can certainly start to do a gifting program, because back to the gentleman's point over here, when you have a breach of more than 50%. So you can start shaving off interests of your LLC up to 50% or 49% to be, and the bank may not find out, but you won't be reassessed. But when you die, sometimes we want to have what's called a fractionalized discount on the properties for estate tax calculations. So gifting is a great idea. This has to be done properly and smartly. And adding your kids on is also a good idea because it enhances the asset protection characteristics of the LLC. The problem with LLCs, an LLC, think of it as a box, okay? It's a shoebox. That's an LLC. And you take your property, right, and you put it inside the shoebox. There's your LLC. I already told you that when the tenant sues you, the LLC provides a force field that they can't get out, right? So they can't get you. It's contained in the box like a tiger. It's like this, yeah? So that's one level of asset protection. Another level of asset protection is when you run the red light, God forbid, and then they're coming after your assets. They can grab the asset. It's one of your assets in an LLC. Now, California is one of the states that says if you have a single owner, they can pierce that LLC and grab it, take the asset, have a foreclosure on it. You say, well, what if I add my spouse? Well, guess what, guys? We're in a community property state. Not only are all assets acquired during marriage community assets, but all liabilities incurred during marriage are community liabilities, right? So one spouse runs the red light, you have a community liability. And how do you satisfy community liabilities? From community property assets, husband and wife, still one member. But if we add your kids onto the LLC, now we have an innocent third party. And now it prevents a third party from reaching in and grabbing the assets from you. So adding your kids on as a member of an LLC is a great idea. It enhances the asset protection characteristics of the LLC and can give you estate tax benefits by doing what's called fractionalized discounting.
And getting back to the stuff up in basis, supposing that the son or the daughter owns, let's say, 25% of it
Right.
over time.
Right.
So the other 75% belongs to the parent, right?
Yes.
So when the parent dies, will the son or daughter get a step-up based on the 75%?
Yes. 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 Yes.
So if that's true, then what is better? Better to keep the percentage of ownership by the son or daughter as minimal as possible?
Yeah, sure.
And rather than give them 25
Sure.
or 50?
The case in question that talked about having a third party on to enhance the asset protection said, as long as they have a peppercorn interest. And what does that mean legally? 1%, 5%, something small. Yes, sir.
Can I, another variation on the same example. So property, let's just round number, $1 million piece of property.
And let's say that, if the one parent was the owner of the property, whatever. What if we say brought a child in on this piece of property? The child now is on the loan. So the father and the daughter get a loan from the bank. But then in the LLC, you say the daughter only has 10%, even though she's 50-50 on the loan. It is, as far as the bank is concerned, it is still 100% those two people. The bank doesn't care that it's 10%.
As long as you're getting their check.
Great, thank you.
Okay. Okay. Do you want to take a break or just continue?
I guess if people want
Hey, you want to help yourself.
Yeah, and then I'm going to try to fix this webinar.
Okay, sure. Yes, ma'am.
I'm I have properties. I'm trying to see what the advantage is of putting them in LL.
Okay, we're gonna get to that. Okay, because that's actually coming right up. Anything else on that? Let me see. Did I cover all this for you? So for community property, does surviving spouse get a step-up basis? Yes. See, in all the non-community property states, they only get a 50% step-up basis. So that's what I'm saying. For California, we get a double step-up. So when the first spouse dies, you get a 100% step-up, and then you can sell. And if you don't sell, you can on second spouse's death.
Hi, Sarah.
Get another
from East Bay Rental Housing.
Whereas in
okay, so I'm up here. We're in the middle of a quick break, so I can talk to you. Okay, do you think you could run me through this again? I have the instructions, but
the surviving spouse stays the same.
But I just want to make sure I'm doing it right.
It's kind of a bummer. So two of the nice things about
so I'm on the view right now that has the menu up at the top.
This is going in and out of the LLC or something. I actually did that recently with the
Okay, my webinar. So I do not see that.
bank.
See, right now I'm.
Hardly said anything for a year and then he decided.
Well, all you have to do is add the LLC on as an additional insured. For sure.
Oh, okay. Just one
second.
second.
Policy per se, but adding the LLC on as an additional. Oh, okay.
Yeah, I don't see that.
Not a problem, the LLCs, you gotta pay that.
Yes, I am.
Yeah.
Above a certain level, it's a couple $1,000s a year.
Yeah, you can do that.
If your gross receipts of 250,000 or less, it's $800 a year. If you go to the next 500,000, you have to tack on another like $900, $1,700 a year. Just trust me, it's worth it.
Yeah, it's worth it. So does the timing in that example that I used, if you recall it, does the
Okay, see, I wasn't even in there. So just
when,
one second.
So when you get the loan, when you add the child, is there something critical or something you should watch out for the timing of that?
Now, the thing is, it's the lenders and banks do not routinely go scouring the records to see who the true owner is.
Okay, so it's actually
And as long as
signed
that
on.
check is being made, man, they don't care.
Yeah.
They don't care. So
No.
I just want to make sure that you're not confusing the due on sale issues with the property reassessment issues, because that's a bigger deal.
So
Let me see. Let me try signing on and see what happens.
That just means that's the bank's resource.
Yeah, he's just
for
completely
you
signed out.
giving their collateral away to somebody else.
Let's see.
That's all.
yeah,
Right, so I think they're actually finishing up. I think it's okay if we just resume as is.
15%,
I think we'll just
And you
figure
have
out
it's
what to do
10%,
And you got
with
no
those
problem
people.
with reassessment either.
It is
And
slideshow,
totally
so-
cool.
even
We can-
though child spouse on this loan, I mean, it looks like 50-50 on the loan,
Yeah.
but that's not what's important. What's important is what the LLC says.
And when
Okay,
someone
yeah, we
sues
can, we
you,
can do that.
they don't
Just go
care
ahead and
who's gonna
start
be the trust.
now
They want to
and just leave it as is because I think they're ready to
Right.
get going on again.
On the deed of trust.
Thank you. Thanks for your help.
That's the debt.
But the deed of trust is what's recorded, so
Yeah,
isn't
the
that
deed
the
of
true
trust is
owner?
the debt. It's the debt. No, the deed of trust is the debt. That's the bank file. That's why when you pay your loan off, you get a deed of full reconveyance back. That's just that removes the deed of trust. You want it's the grant deed that shows who the owner is, or in your case, the LLC, the membership into the LLC.
The grant.
Don't confuse the debt with the asset.
Okay.
And I'm saying that on the debt side, the bank has a recourse of a due on sale if you're fiddling with their collateral. That's debt. The asset is a property reassessment on the assessor side.
Right.
And in California, it's brutal on the Prop 13, right?
Yeah.
So, because if you pay off your mortgage, then you'll never have a due on sale clause because there's no bank.
There is no bank.
But you still got reassessment.
So it's the grantee that determines who the actual owner is.
Or in an LLC, who the members are.
Gotcha. Thank you.
Yeah, no problem. I'm sorry, this study was.
Oh, I'm
just
sorry.
a moment. Yes.
Hi, I own 3 houses as tenants in common with my brother.
Yep.
If I take one of the houses, which is worth approximately $1 million,
Yep.
and I liquidate it, I sell it,
Yep.
what would my capital gains be?
It would be 15% of whatever that is.
50% of
Of
the
the,
million?
yeah, 500, because you sell it, and you got $500,000 in gain, or assuming what's your original basis on that $1 million property?
What do you mean originally?
What did you and your brother buy it for?
We inherited it.
Okay, well,
and I
okay,
don't
what
know
was the
it
date of death value
I
when
don't
mom
know
and
what
dad
it
passed?
was worth.
You got to find out. You can have an appraiser go back and do an appraisal based upon date of death values back in time. They can do that.
Okay, so go back in time.
Oh, yeah.
How hard is it to get liquidated for my brother?
That's between you and your brother. That's a question you got to ask yourself.
No, but it's tenants in common.
Not a problem. You could still petition the property. Not a problem. You could sell, but most likely you want him to come along with it. Because as a buyer, I ain't want to buy half a property with a hostile co-owner.
So if it's $1 million worth $1 million, and my brother owns 500,000 of it,
Right. And
I own 500,000 of it.
yeah, the gain question is depend what was the value when mom and dad passed away you inherited. That would determine your gain corridor. That's why you have to get it appraised.
Okay.
It's called that data. You want the highest defensible value of the date of death value from mom and dad.
So there's not such a big difference between the two numbers?
Yeah, you want to shrink that corridor down,
Okay,
that gain corridor.
thank you.
No problem.
Now, I wonder if you don't have a significant other
Mhm.
and you don't have a child,
Mhm.
if you want to put it in the LLC, can you have like a business partner?
Yeah, sure. If you want to give your business partner half your interest, I got a better idea for you, man. I got a better idea.
And what would that be?
Okay, I'll tell you. I'll get to the second.
LLCs,
Yeah.
is that what you are recommending that all title to property be held in?
Okay, great. So that's a great question, right? For all of us that are involved in real estate, there really is only one proper way to do this. And I'm going to address Late's question also about trust, right? So what's with the trust and all this LLC stuff? What's the benefits?
Mm-hmm.
Well, let me first address the LLC question, and then we'll kind of show how it ties in with the trust. The LLCs have a pedigree based upon partnership law, partnership taxation law. So that's the first good thing, okay? Which means that when you put property in and out of an LLC, you don't have a capital gain transaction, okay? And I see people that have mistakes. They put real estate in corporations that are taxed as S or C. Massive problem. Because when you pull properties in or out, the IRS deems it a capital transaction. You have capital gains or capital losses. Tax problem. So you first want to use an entity that has passed through taxation at a partnership level, which is either an LLC or a limited partnership. Okay, that's question number one, answer number one. The second part of the answer has to do with the asset protection components. LLCs are designed to provide asset protection from two different directions. You have, as I already gave you the example of the tenant, right? The no good tenant is in the cage. You want them like you're at the zoo, right? And you don't want them the lion to eat your face off, right? So you're on the outside of the cage. That's like the tenant. The tenant's going to sue you. That's what they're good for, right? Not paying rent and suing landlords. Other tenants are good for, right? And so here, you want to protect yourself from the tenant as much as possible. So you want to cage them inside an LLC. So LLCs protect you that way, but so do corporations. But now here's the big difference. The big difference is you. Not only is the asset a potential threat to you, but you are a threat to the asset. It's your asset. You and I get into a car accident and I sue you. What's one of your assets? Your $1 million apartment building. Don't you want to protect that from me taken away from you? Corporations don't. I can take the corporation stock and I become the owner of the company. LLCs prevent that from happening. It's called an outside creditor. It's called a charging order protection.
It's called
But
what?
a charging order protection, charging order. But it only works, to this gentleman's point, when you have multiple members on the LLC, a multi-member LLC. That was my whole rant about that whole adding a third party. It can't be just husband and wife unless you have a post-marital agreement or something, because you have community property issues. And you can add a third party on there. If you don't have a kid and you ain't got a spouse, you can make another LLC that you own and let that be 95-5. At the end of the day, who owns the whole lot? You do, but you have legally two owners.
So two.
Yes, one is just a member, one actually holds the property. So what's your name, sir? Kelvin. So you would have Kelvin RE Holdings owned 90% by Kelvin the individual and by Kelvin Investment LLC, 10%. You own the lot, so it's still you 100%, but legally it's multi-member protected. Or better yet, I put you in a jurisdiction that respects single member LLCs, not California. This is where you have Nevadas, Wyomings, the Delawares, Alaska, South Dakota. This is where you hear people using other states. Because California doesn't respect that single ownership, but Nevada does, Delaware does, South Dakota does, Alaska does. So if I'm working for you, where am I going to put you as a single individual? In one of those preferred jurisdictions. From the outside world. Now, don't confuse me. You still have to register it in California. So you would be a Nevada LLC registered to do business in California. You ain't getting out $800. You got to pay it still. Okay? Because the FTB says if you're the manager, which you are, and you breathe California air, which you do, you're doing business in California and you got to pay Jerry about $800 a year. Period.
So
deductible.
So the one that owns 95%, we would put that like in Nevada?
Yeah. No, whatever. I'm saying whatever. You get the idea. I'm saying we can accomplish it. Yeah. Yes, sir.
So, which state's rule? You have, let's say, take your example. You establish your LLC in Nevada or Wyoming, whatever, Alaska.
Right.
But you have to register the LLC in California.
Right.
If there's ever a lawsuit,
yeah.
Which state controls?
Okay, think about this, right? Think about this. Who's the plaintiff? Let's start with that.
Say tenant.
The tenant. Okay, so the tenant is inside the box. The tenant is going to sue you in California tort law. California law is going to govern. That's why you have to be registered in California. You want your LLC to have standing to go to court to defend itself, yeah? Yeah, good idea. That's why you need California registration. That's happening inside. But in my example, from the outside, if you get into a car accident and someone's trying to steal your property, you still have the liability exposure between you and the car accident, California negligence tort law. But then they're going to go for the remedy. Hey, mister, give me your LLC. Now the laws of Delaware come in and protect that LLC. So if you're looking from the inside, California tort law, that's all. But if you're looking from the outside, the force field you put in, that's the Nevada, the Delaware. You see? Depends. I always have to know who the plaintiff is.
Okay. So in this case here, it sounds like you're not losing $800 in California. You do get some benefit from the inside protection.
Absolutely.
Okay.
Absolutely. And listen, after you pay your taxes, after you deduct it against your income, it's $400. If you guys can't pay $400 to run your business, you're in the wrong business. Period. You should be cash flowing $400. Yeah.
Okay, so what would we do if we have a
there's a trust question.
umbrella liability
Perfect.
policy?
Right.
Why would you need LLC?
Okay, great. So here's the story. I'll give you a perfect example I'm working with right now. I'll give you two examples I'm working with. So the first example is like this. I have a lady, this is in the LA area. She she had a rental property. This was a long-term tenant, single family home, long-term tenant. The lady left a lit candle on the mantle overnight. Don't ask me how it happened. The cat knocked it over or whatever. Let's just say the house burnt down. The baby was killed. The child was killed. The mom, trying to save the two kids, was killed. The father and the son got out. Got 3 dead people, right, in a fire. So I have a complaint on my desk for wrongful death for $12 million. I have a letter from State Farm saying, we're going to totally cover you. $3 million. So I have a wrongful death claim at 12. I have insurance at 3. What's my deficiency? 9. Where does that $9 million go? The client, by the way, is worth about $8.5 million. So is that worth $800?
Yes.
Otherwise, that $9 million deficiency would have been contained, just like my Tiger, but they didn't do that. Right? Second thing is, you have the car accident or whatever, the slip and fall on the property, and the next thing is, oh, by the way, not only is it policy limits, but then you have a guy that shows up at your front door. He's called the insurance adjuster, right? And they only seem to adjust in one direction. One direction is down. Right? Right? So now you may have a $5 million policy, but I'm going to cover you for X amount after you pay your own deductible. Okay? So and the second thing is, what if you just plain old excluded? Plain old excluded. Oh, here's another example. San Bernardino County, another client of mine, nice real estate lady. She has a property out in San Bernardino. She's got a big dog, the St. Bernard dog, right? And the neighbor has got little dog with big attitude, right? And finally, the big dog gets out of the kennel and he goes and starts munching on little dog. Little dog owner comes out and tries to separate the dogs from fighting. So what does big dog do to little dog owner's face? She rips the face off. And now she's suing my client for $550,000. Oh, by the way, that big dog on the insurance policy excluded. She had coverage specifically excluded. Dogs with known dangerous propensities. You know who they are. Pit bulls, Rottweilers, Dobermans, Chows, right? They're exclusions. And when you look at your insurance policy, how many pages is your policy? Let's just take a guess.
A book.
Okay, I've seen enough of them. How about 30? Maybe 40. Double-sided. Dual column. 6-point font. And page 1, paragraph 1 says, you're covered for the following items. And all the other 29 pages are what? Exclusions. All the exclusions. All the rest. And I asked you, how many of you have read your homeowner and renter's policy? Right? I normally just say you've seen it. I forget the red question. I go straight to seen it. Right? So you have a false sense of security. And some of the country's largest law firms are insurance companies. They're owned by insurance companies. So the big clients. They're not trying to find all these creative ways to pay you. All right, so understand that an insurance policy is part of an asset protection plan, but it has to work in tandem with your LLCs. It's still the first line of defense. Sorry, it was an accident. I have $2 million, but don't take my house away from me. It was an accident. That's why you put this in play. All right? I'm kind of going all over the place, but let me answer this Nestle's question. Same way. She had a question about a trust. What is it about a trust? We're talking about LLCs and we're talking about estate planning. And so what is it about trusts? So I get a big question all the time. Hey, Brad, I don't need any kind of asset protection for my rental property. They're all on my trust. I worked with my lawyer. He did the deed. They're all in the trust. Okay, great. So I'm inherently protected. And the answer is no, you're not. And the reason is because it goes down to the trust itself. Who's the trust creator? Most likely it's you. Typically the husband and wife are the trust maker. Who's the trustee? That is the owner and manager of the contents of the trust. Well, it's my husband and wife. So it's you and you. Who retains the power to revoke and modify the trust? Oh, you do, yeah. Who has the power to put assets in the trust? And who has the power to take assets out of the trust? You do. In other words, you exercise so much dominion and control over that trust. It doesn't even have its own EIN number. There's no even legal fiction to attempt to make it deem a separate entity. It's you. So when the trust gets sued, you get sued. Regular family revocable trusts offer zero asset protection. Think of it this way, by reverse implication. If a trust gave you asset protection, why would anybody form a corporation? Why would anybody form an LLC? Hey, save the $800. Just do business as a sole proprietor in your trust. And y'all know that that's the wrong answer, right? Right. So you still have to have an asset protection entity. Now, what's with the entity? You put that in your trust for probate avoidance. Don't confuse probate protection with asset protection. Totally different. Too much control. Yes, sir.
Just to be clear, just because you have the LLC, it's still important that your LLC is in the trust. Is that what you just said?
100% correct. 100% correct. When you pass away, or think of it like this. Think of it like this. You pass away. I have a client, all right? This is another. I tell the guy he's a contractor. He makes big box stores. He builds the Best Buys, the Starbucks, the PetSmarts, these big box buildings. This happened to have been a corporation, but exactly the same thing with the LLC. I go to him, Bob, and say, hey, Bob, we need to take your LLC, in this case it's corporate stock, and put it inside your trust for probate avoidance. He says, Brad, I really don't want to do that because every single time I need to bid on a contract, I got to provide evidence of my ownership of the company and insurance and this and that. Not to mention, he could just have signed the back of the certificate of the LLC. So here's what happens. So he passes away. He's entertaining one of his buddies during lunchtime. Drunk driver into a tree, puts the partner through the windshield, and he dies, right? So he gets sued. His company now goes into probate. He has a trust, remember. He didn't put the asset in trust. So he has a trust. His house didn't go to probate. His bank account didn't go to probate. His retirement funds didn't go to probate. Life insurance didn't go to probate. But his biggest asset, the contracting business, went to probate. So who now owns the contractor business? The state of California, at least while we're in the probate process. So now, while he's in the probate process, he can't do anything. What happened to his Starbucks contract, his Best Buy contract? What happened?
Can't verify the owners.
Gone. A $5.5 million asset turned into liquidation of some scaffolding and some used trucks. Yeah. Why? Because he didn't want to fill a piece of paper off the back to put the certificate in his trust. He didn't listen to his lawyer.
Question.
So these things have to work together. So the estate planning and the trusts, titling and hopefully you're picking up the titling the LLC, the deeds, who owns the membership interest, who are the beneficiaries of these policies. All this makes, so estate planning isn't just about who gets your stuff when you die. You also need to make sure that the assets are talking to the plan. Because if the plan is saying, like in my example with the little lady, the kids, a third, but the good son got the account for $250 on joint tenancy, that's not talking to each other.
In your earlier example where there was a $9 million difference between what the insurance would cover, if that property would have been in an LLC, how would it have protected? Can you talk about?
Yeah, sure. I don't have a whiteboard, which is kind of a bummer, but it's very simple. Okay, you take your property and you put it inside the LLC, right? You have the insurance policy, $3 million, which is reasonable insurance. They weren't underinsured for what they were doing. $3 million is reasonable. It was a State Farm policy. So here, slip and fall, fire, liability, drown in the pool, whatever, make up the facts. Now you have, remember, this is now in the LLC. Okay, it's my caged tiger, remember? Mm-hmm. Now, when they sue you, their entire universe is limited to what's inside the box. What's inside the box? The insurance policy and the property itself. That's it. You can't just pierce it and come after me, my client.
Your other stuff.
The other stuff.
Yeah.
But you do lose the property.
Oh, yeah. So what's the lesson here?
You want an LLC for everything.
Everything. And how many properties do we put in the LLC? The amount you want to lose. If you have 2 properties, all right, you got your commercial building and you got your single family home. You put them both in the LLC. Let's say this is your owner-occupied building, right? This is where you work. This is where your earnings come from. And you want to get cheap. You don't want to pay California $800 times 2. So you then take your rental, your slumlord property, right, and you put it inside the same LLC. Where's the problem? The problem happened on the slumlord property. But remember, both of these are inside the same LLC. So when this guy sues you, what did I tell you? They sue the whole universe in the box. What else is in the box besides the slumlord property that has no value? Your commercial building. And there's 2 ways that you lose negotiating position. I call them pain points. There's 2 pain points that we push that make you roll over and lose negotiating position. 1, I threaten your business. If I go to you and I say, excuse me, sir, you realize that because of this problem here, you're going to be now without a job because I'm going to take your property away from you, your business away from you. That's a problem. And the second thing is when we threaten your house, taking your house away. And if you don't care, wait until your wife finds out. Right? That's another pain point. So if you have property, I call this no value and value. You don't put them in the same buckets. You have no value holdings and you have value holdings. A slip and fall over here, they take all of this. You lost it, whatever. They can't just pop over and take your commercial building. You need to isolate and insulate. You need to create multiple LLCs based upon what you're holding. Not to say that you can't put multiple properties inside one LLC, but don't put it in there when it's got equity in it. If you got no equity, I got a client who has 6 pieces of property in the Everglades in Florida and no value. He said, put them all inside one bucket, no value holdings. As a matter of fact, you hope they sue you. But they can take all the properties and you get out of that bad investment. But you don't take your nice property and put it in the same bucket. You see what I'm saying?
Yeah, I do. One confusion point for me. If the LLC protects me anyway, you're saying you lose this slumlord property or you lose this other one? I thought the LLC is protecting me from beyond.
No, yes, they didn't get anything else, right? You took your commercial building and your slumlord property, right?
So under the LLC, they can still take your property?
Yeah, the properties are gone, but they can't get to you.
You ain't got nothing to call you guys your property.
Yeah, let's say you got the $5 million, like my fire, $12 million. Slumlord is worth nothing, that's gone. Your commercial building is $2 million. So here you got a net liability of $10 million. That's it. It goes away. They can't sue you. That's why it's in an LLC. All I'm saying is that you don't want to put a lot of assets, too many eggs in one basket.
If your commercial building or your biggest property, apartment building is worth a lot of money, how do you, and you want to really protect that one, you had a slip and fall, you had a big judgment, you mean it's going to be that you're going to lose that big building? Is there a way you could have saved?
Absolutely.
How?
Equity stripping.
Equity stripping?
Equity stripping. Suck the equity out. When I sue
you, put loans on it, you mean?
Possibly. That's one way. Think about it. When I sue you, I don't do that type of law, by the way. I'm on the defense. I'm on your side. When the guy, right, sues you, do they truly want the dirt?
They want the value.
They want the value that the dirt represents. Okay, so we have $1 million property. It's got no debt on it. It's worth $1 million. After fire sale and cost of sale, maybe they net $700,000 on it. And they'll use that. Okay, you lost your property, they got $700,000. But it was an attractive asset because it had $1 million of equity. But what if we were able to put liens or equity strip this property? Well, now it's worth $1 million, but it's got debt on it of $900,000. What's the equity now? Okay, now I put you into a fire sale of a sheriff foreclosure sale, a judicial foreclosure sale. Are you going to get $1 million on an auction on $1 million property? No. What are you going to get? Let's say though you get a 20% discount or even a 15% discount on the auction. Now the property goes for $850,000. How much is my liens on there that have first priority? 9. I made an attractive asset unattractive. What did I do with the cash? I put the cash someplace safe. The cash is maybe in another LLC or into another asset protection trust. You sucked out the equity. It's called equity stripping. Now, when you have your properties inside the bad bucket, they have no value because all the value is over here.
When
right?
did you start equity stripping becomes the question.
When and how?
There's multiple ways of doing it. I mean, there are multiple ways of doing it. I'll give you just a very simple example. Anybody here occupy a building that you own? Owner occupied. Okay, great. Okay, so I'll throw a number out here. Let's say that you rent your own building for $10,000 a month. Yeah, $5,000 a month. Whatever, $5,000 a month. So how much is that per year? 60 grand a year. And we're in a 20-year long-term lease with ourselves. So 60 grand times 20 is how much? How much? It's a lot, right? It's a lot. $1 million at least, maybe? 1.2. Okay, 1.2 million, thank you. And how much equity is in our property? $1 million. Okay, now if you come to me and say, Brad, I want to rent your property. I want a 20-year long-term lease. Are you going to want some type of personal guarantee from me? So if I walk away from the lease, you can collect on my obligation?
Yes.
Okay, why don't you do it to yourself? So you are a tenant in your own building. You could then use that unfunded personal obligation to put a legitimate lien on your own occupied building. Completely legit. That's one option. Any of us borrow money from mom? Want to admit it? Any of us borrow money from the company? Yes. Any of us have an unfunded liability out there in any place? Right? Why don't someone lent us money? Even if it was mom. Mom ain't going to sue you to collect on it, but you owe mom money legitimately. So you say, Mom, I'll promise to pay you back, and I'll even put a promissory and I'll secure it against my commercial building. There's another $300,000 on a recorded perfected deed. Due on demand. Mom ain't ever going to sue you. But that's a legitimate loan. So now we're basically equity stripping by these unfunded liabilities. And then for that small differential, hey, go get an equity line. Suck that out and put it in the bank account. You took an attractive asset worth $1 million and it's now nothing but debt. We don't sue you to take your debt-riddled assets. We want to get paid at the end of the day too.
But another point there, people who are targeting properties for fraud are looking for properties that are debt.
And public records, okay? So I have a privacy solution that I came up with a handful of years ago. Situation came up like this. Not only was a celebrity client, but we also have sports figures who do the sport. A guy comes to me and says, Brad, I have a client of mine. In this case, he was the collection business, and another situation that occurred for a celebrity and another situation that occurred with a tenant. 3 o'clock in the morning, the tenant's knocking on his door. Fix my toilets, man. I told you, fix my toilets. How did he even find out where you lived? You have a property manager, the whole deal. All he had to do is go on to the public records and the Social Franchise Tax Board or Secretary's office and type in the name of where he's writing the checks to, and there's your residence. Another situation I had with a debt collecting client, 3 o'clock in the morning, the guy shows up, puts a gun in his face and says, stop trying to collect the debt on me. How did he find out where I lived? I have a celebrity client and has got this lady who's making him crazy, creates a fake Facebook account, puts his front door, a picture of his front door on a fake Facebook and puts it all out in the public domain. How is this happening? It's very simple. Companies and real estate are all a matter of public record. So with a privacy solution, you get your name off the public records. Poof, you go away. Not only purely from a asset protection, low profile, but more importantly, to your point, ma'am, are you worth suing? When someone's going to scope you out, remember who's funding the litigation to sue you. It's the lawyers, right? No skin out of your pocket, right? We just take a 30 or 40% contingency fee, but we'll fund the litigation. But we want to sniff out, are you worth suing? So we're checking the public records. And one, it shows out everything's full of debt because borrowed money from mom. Or you don't even exist. Doesn't even show up because you have a low public profile. And I have a privacy solution I offer my clients for that exact reason. I service a business owner environment. Good off public records. Question?
So you have your trust, you funded it with 4 pieces of property. They're not in LLCs.
Right.
So you then create individual LLCs for the 4 properties.
2, 3, however many. Right,
Then
right.
you then put that into the trust, you amend your trust? Is that how you-
No, the trust has nothing to do with the assets that it owns. The trust just has a dispositive provisions on who inherits when you pass away.
So you don't have to list that you now have LLCs?
No,
and-
but the LLCs have to be titled or assigned to the trust.
Okay.
There is a document. It's called an assignment of membership interest,
Okay.
and that's what takes the LLC and puts it inside your trust box.
Okay.
There's no need to amend the trust unless you want to put a provision that says, I want little Johnny to get ABC Holdings LLC specifically. You have a specific distribution of that asset. Otherwise, if it's just equally among my kids, let them fight it out, right?
So you don't designate, you don't put down as one of the members of LLC the living trust.
No, that's fine. That could work too.
You can do, or
But-
you don't have to do that, but you just fill out a form that if something happens to the members,
That's right.
you assign it automatically.
Beforehand, right? Or in the example I gave with the guy, the contractor, the certificate itself will have a legend. It's called an assignment on the back of the actual printed certificate. And you fill out right here, I transfer my asset to the ABC Family Trust, and you sign it. That's it. You did it. If you don't have that, sometimes they're blank in the back. You have a assignment separate from a certificate that you sign, and you staple it. That's the same thing. Or the LLC, the name of the original member is ABC Family Trust. Either way, we'll all accomplish the same goal.
Okay. So in a situation where you have one of the members the parents and the second member is the son, how do you handle the linkage of the LLC into the living trust? What would be the best way to handle it?
Parents can only put their portion in, and son would put his into his trust. And then maybe parents would just list son as the beneficiary of that asset. So when mom and dad die, son already had 15%, and then he inherits the other 85%. Yes.
Okay.
All right, we're good. We're good. I don't know how you guys are doing on time.
I'm fine. I'm fine.
You're fine. It's 1:30. You guys okay? I'll just keep on going.
Yes.
Okay.
Can you talk about the Trump tax plan?
Sure. Sure.
The intricacies for
Okay.
small business people?
Okay. What I'm not going to talk about, because I don't even have a good handle on it, on what's with this S corporation thing, right? He's got something in there which is a little crazy. So I'm just going to limit my conversation with the Trump tax plan strictly to the estate tax arena, right? As I already mentioned in my opening comments, that the exemption has gone up very, very high. So that each individual person, each U.S. resident has a $11 million exemption. And if you're married, you double it up, so you get $22 million. But that's only until 2025, okay? At 2025, it's going to go back down to the $5 million, but index. So maybe it'd be about $5.8 million per person, maybe about $10 million, $11 million total for a married couple. That's the extent I want to talk about on the Trump tax law. Because other stuff deals with income tax issues, and I'm not a CPA. That's not my area. I'm an estate guy, not a tax planner. Okay. Good question. I'm gonna dodge that one. Okay. Okay, great. All right, so basically getting back to some of the estate planning stuff, we have estate settlement fees, probate fees, attorney's fees, estate taxes. And so in the improperly arranged estates, insufficient liquidities for paying estate taxes, unintentional disinheritances, we spoke about already with joint tenancy examples, and then trust fund babies where you leave too much money for a kid without proper safeguards. Another thing I want to point out, and this is a very important slide, is because when most people think of estate planning, they think of it purely as death documents, right? Who gets my stuff when I die, right? They think of it purely as death documents. And I can tell you, having done administration for over 2 decades, that some of the most complicated and long-term administrations are not when someone dies. It's when somebody becomes incapacitated, right? Think about this. I told you when someone dies, how long to tell you the administration will be? About how many months?
18 months.
About 18 months. Right. You muster up all the assets, you pay out the debts, you file income taxes, you set up a couple of accounts, and whammo, it's on autopilot. 18 months. But God forbid you get into a car accident and you become incapacitated. Now you need someone to act for you for the next 20 years. You can't manage your own finances. You can't manage your own healthcare decisions. You can't file your taxes. You can't manage your property. Someone has to do it for you. So everyone's so busy thinking about the wills and the trust, but what about this? These documents are probably, in my opinion, the most important documents for you. The powers of attorney for healthcare and property management. So here, in the financial side, elderly parents is a big deal, right? I have a client of mine, her name is Elaine. This is a nice little story, a very close friend of mine. She says to me, she says, Brad, we put my mom into a long-term care facility. She's starting to go a little cuckoo, right? And I'm getting copied on her bank statements. And I'm seeing all of a sudden these checks are being written to the guy in the neighboring apartment who's like chummying up to dear old mom. After a little bit of investigation, it turns out the guy is a former Vegas gambler. He's starting to woo mom, subjecting mom to some undue influence, right? And I say, Elaine, no problem. I said, do you have a power of attorney for your mother? She goes, no, we don't. I said, Elaine, not a problem. Here's what we're going to do. We're going to take mom. We're going to bring her down to the courthouse, and we're going to say, in this public setting, we're going to say, Your Honor, she's nuts. She's so nuts, I want you to strip away her independence and appoint me on as her conservator so I can take care of mom. And so the old story, the old joke goes, how do you know when a lawyer is lying? His lips are moving, right? So the court says, Counselor, that's great. I'm going to send out my own private investigator to find out if mom truly has lost it. So now the court investigator comes and the social worker goes and visits with mom. Everyone knows who they are, the big embarrassment, the big tumult, and all of a sudden they come back and report, yes, mom's nuts. So you can now take over mom's finances. So how many of us in this room are going to do that to dear old mom? That's what I thought. And it happens all the time. Elder abuse can come from kids. It can come from boyfriends, girlfriends, daycare assistants. It can come from, they could be hoarders in the property, all kinds of problems. And the kids can't do anything with the property. So change the facts. I say, hey, Elaine, do you have power of attorney for mom? Yeah, Brad, I sure do. Here it is. Great. Here's what we're going to do. We're going to go down to Wells Fargo. We'll open up an account in the name of you as her power of attorney. We're going to take mom's $250,000. We're going to take $245,000 of it, and we're going to put it into your name, the good son, as mom's POA. We're going to leave mom $5,000 in the account so she can get her hair done, buy the groceries, buy some shopping on Amazon, right? But when the $50,000 check gets written to the Vegas boyfriend gambler guy, what happens to it? It bounces like a basketball. And mom doesn't know from nothing. Awesome, right? Another area we have is the impact on business, right? So all of us anybody have business partners? Everybody? Okay, we'll skip that example. Okay. So next, another one we have to deal with is with advanced healthcare directives. So this is when you're appointing someone to make medical decisions for you if you can't make them for yourself. right? So here again, it's pretty self-explanatory, medical power. But not only is it the power to authorize someone to make medical decisions, it's also the place where you can put an affirmative statement saying, under some circumstances, I don't want to receive medical care, right? It's an acknowledgement that modern technology has made possible the artificial prolongation of our life beyond natural means. And but for the human intervention, because of comas or brain incapacities, you would have passed away within a matter of months, weeks, hours, anything lesser included, right? In other words, pull the plug, right? All you're doing is artificially delaying the moment of my natural passing. Pull the plug and let my body do what it's going to do. But at the same time, I want to receive enough medical care for my comfort and to alleviate pain, right? To pull the plug, but don't let me feel it. That needs to be in there too. And y'all heard about that Terry Shiloh case about 20 years ago, but that was a circus. That was the problem. You had two conflicting people. The husband saying, pull the plug, pull the plug, pull the plug. Mom and dad, miracle, miracle, miracle. And what happened? Terry herself went on for all the way to the Florida Supreme Court, right? So you have the place to make the affirmative statement saying under these narrow circumstances for emotional stress, financial stress, pull the plug, right? That's there. And for those of us that are concerned, you know, again, I have all kinds of clients. People are concerned about, hey, this is a suicide thing and purgatory, and they kind of freak out when it's religious. It's not a problem because this is not a suicide thing. If you think about it theologically, all you're doing is removing man's intervention with God's divine plan. All right? It's not a suicide thing. So you can talk to your religious people and find out what your rules are on that. But just don't freak out about that. So you got Natural Death Act. If you have final wishes, some of us, it's very important, burial versus cremation. You want to make sure they're in there. It's important. Some of us also, again, for religious purposes, burial. They don't want to be cremated. But unless you let people know about it, you know, hey, kids come, hey, it's cheap, it's green, you know, burn them. That may be a problem for you. You need to let this is guidance you're giving to your kids for you. Also on anatomicals, people are organ donors. A lot of people have very kindly put a pink dot on their driver's license. And all that is a big yes under the Uniform Anatomical Gifting Act without any direction. When I ask people the next question, so if you're okay with organ donation, are you okay with their body being used for medical research and being used as a teaching cadaver at the local medical school? I'm like, nah, I really didn't have that in mind. What I really meant was as long as I'm helping another human being directly. Okay, well, let's say that. Let's say that you're okay with anatomicals, but it's limited to direct human beneficiaries, not institutional beneficiaries. Let's put it in there. Very important stuff. And also long-term care guidelines. This is more prevents elder abuse because if you do have kids that they think mom and dad is checked out and they put them into some crummy location down in the bad part of town. They said, mom and dad checked out, what do we care, right? Trying to preserve the inheritance. You want something in the document that says that you want a quality care facility close to friends and family, least restrictive, most home-like, offers social interactions, outdoor activities, right? So you can be treated with some dignity in your final days. And so someone can hold the kids accountable and prevent them from, not treating you with dignity, right? You got to put the stuff in the document. You got to put it in writing. You need clear and convincing evidence to hold people accountable. So this is very important stuff for you. Yes, sir.
So I have I work for a electrical contractor, and his mother, him and his mother and brother owned the business, and his daughter, so the granddaughter, was the office manager with mom. And she was also named our executor of the will. So when mom dies, and the will comes out, there's and mind you, the problem being the granddaughter and the mom have the same name. Mm-hmm. So he named the daughter after grandma. Mm-hmm. So they have the same name. How do you prevent the granddaughter from pretending to be mom and commingling the business assets with the trust assets.
Actually, good. It's a good point.
Because that's exactly what happens.
Yeah, typically what happens, the documents will identify kids. They'll normally identify them as dates of birth, social security numbers, statuses, my daughter, my grandchildren. So there's something in there, and whomever is dealing with them, whether it's banks or taxing authorities or the court, will require you to kind of verify who you are in relationship to the decedent, right? So there are some built-in safeguards. The fact that you have the same name by itself shouldn't really prevent them from being able to protect the assets. You know?
Right, but it does create a.
Oh, it certainly does. Yeah, absolutely. Yeah, certainly does. Okay, so I know I got some people walking out here, so I'm going to go ahead and just let's just go until another 5 minutes. That brings us to 1:45, and it's way past the time. But let me just open up to any kind of last questions. In the meantime, please go ahead and fill out this yellow card, and give me your contact information. My office will call you. Get on my calendar. We'll talk for an hour of free time, address any additional questions. I'd love to work with you. Okay, it won't cost you any money. Just go ahead and fill us out. If you have existing documents, email them to me in advance. I'd be more than happy to look at it, give you some commentary, good, bad, things that can be improved upon. All right, and I'll click this at the end. So why don't you go all work on that, and then I'll just take any last couple of questions. Did I answer your question about the LLC thing, yeah?
Yes.
Thank you. Thank you. I got you about the step up in basis. Yes.
So the LLC, you
Yeah.
need an employee identification number, $800 to file with the state.
Mm.
You need the assignment of membership.
That's right.
To
The
the
trust,
trust.
right?
Anything else we need to do?
Yeah, you have to have you mentioned operating agreements already?
No.
Yeah.
Operating
Yeah.
agreement? Okay.
So typically you can go on to, although I'm not a big fan, but there is a marketplace for these online services, right? To form LLCs. The thing is, I would strongly recommend that you work with an asset protection professional. The reason why is because the operating agreement is your own personal constitution, right? And you want that agreement drafted in a way that provides you, the landlord, asset owner, with the greatest protections. And you want to put it, I call poison pills. You want to put all the poison pills. So if someone is trying to attack your entity, your asset, they're gonna get a lot of bad stuff, right? You want, huh?
Yeah, collateral damage.
Yeah, collateral damage, right? If you just go online or just download an off-the-shelf believe me, it's Swiss cheese you're able to get into it. It's not narrowly tailored to match all these.
Okay, so the properties are owned with one sister, another property is owned with a different sister.
Yep.
We create separate
Have to. You have different ownership. You have to.
Does the other party, my sister, have to create her own LLC?
No, you guys can go in together on the one.
Together. And what if she doesn't want to?
She really should. Let me talk to her. I'll change her mind.
Okay.
Yes, sir.
This business of protecting the asset, even inside of that LLC. If a tenant sues, they're going to sue the LLC also.
That's right.
And if they get a judgment, it's going to be against the LLC.
That's right.
We'll have to give up the asset.
That's right.
So the asset, the stripping plan, I think that's very good.
That's right.
Vermont, put all that up. But if you don't do that, which people don't usually, the property is still fully exposed to insurance deficiency from a tenant.
100% correct.
Yeah. And if it's the driving accident that comes at you, they may not get into your property, but they'll get your assets. And one of your assets is your share of the LLC.
That's not correct. That's not correct.
That's pretty important.
Yeah.
So you're saying that
That's why I mentioned the different jurisdictions, right? You heard me say
but
different.
See, all I really have is property in an LLC. No matter what bad things we do, they'll never get into that. They won't be able to take my LLC share.
Right. That's the goal of asset protection. That's exactly right. That's the goal. That's what I do. That's the goal.
I do find that hard to believe.
Yeah, that's the goal.
So
we can totally do it. Yes.
But you do it by.
But there's all kinds of tools. I have a whole bunch of arrows in the quiver. We got plenty of ways of getting it done. It's a combination of things. It's not just, there's no one silver bullet. There's a bunch of things.
If I just have the LLC.
That's definitely the foundational piece.
And haven't done anything else, any of your other things.
Right.
my LLC shares are still exposed.
Yes, that's correct. Yes, yes, sir.
If you, you said that, if you have a single member LLC.
Yeah.
And you, and it sounds like, places like Nevada or Delaware or gives the single member LLC greater protection than if they had a single member LLC in California.
Right.
Is that, if you did that and you form a single member LLC in say, Nevada, does it get the same amount of limited liability, personal liability protection as a multi-member LLC if you created that in Nevada?
Yeah.
You can.
Yeah.
Okay.
Because for some people, like me, the gentleman up front here, they're not married, they have no kids, they really only are a single member. So when we have cases like that, we need to exercise the benefits of those other states that specifically address his scenario.
Okay.
So it's always good if you have multi-member. Multi-member is always better. Always better.
Why is it always
it's a different conversation.
Okay. All right.
Always better. But in some cases you don't have it. So now you have to rely on other states' law.
Okay.
But it can be done. Absolutely.
So would you, once again, you said do 2 LLCs?
That's one option. One option. Yeah. There's always more than way to accomplish things. Always more than one way. Maybe even more than one way. Okay, let me shut down the recording here. I hope that they were able to get enough out of this, considering the limited time that they had online with us.